Too big,
Good
probably.
morning and welcome to Member Focus Monday. I'm Christina Schaefer, Director of Social Media for HAR, and I'm pleased to be joined this morning by HAR's legal counsel, Grant Harpold. Welcome back to the program, Grant.
Thank you, Christina. Always fun and a pleasure and an honor to be here.
Thank you. We love to bring you on regularly to give us updates. And there are some updates, some that went into effect February 1st that we want to discuss today. So we've got a lot of great things. And of course, we will always take live questions from our members. So if you have questions for Grant, you can type them in throughout the program. Grant, for those who may not know you yet, if you could just tell us a little bit about yourself, who you are, and what you do.
Well, as you pointed out, legal counsel for HAR, and I've been practicing law for 35 years and board certified in civil trial law and represented brokers and agents for probably 25 to 30 of my years in this practice, on issues concerning risk, operations, anything related to the broker services, real estate industry, and associations. I'm here to help.
Very good. And you also stay very involved with our members. You attend our board meetings, you attend certain advisory group meetings, and really just there to offer support. Is that right?
That's right. That's yes, and I enjoy doing that. So it's like I said, it's an honor and a pleasure.
Excellent. Well, thank you again for taking time for us this morning because, again, there are some updates that we want to discuss, and we'll jump right into them now. There were some changes made to truck contracts that went into effect on February 1st. Can you tell us what changes were made and how they affect our members?
Yeah, overall there were a bunch of type typo type changes in the sense they were changing certain terms in the contract that I guess needed changing, whatever. But I think the sort of the more critical stuff was the fact that agreed to repairs need to be documented, meaning that documentation for the scope of the work that was done under the agreed repairs provision or an amendment that allowed for repairs. That documentation showing that it was done and what was done and that it was paid for and completed needs to be provided on or before closing, or the closing could be extended. It also, in that same provision, which is, I believe, paragraph 7 of the contract, 7, yes, of the contract, it also puts the seller having the burden to arrange a transfer of warranty. Um, if there is a warranty that needs to be transferred, I mean, this sort of comes up in kind of the where you can get snake bit is on the transfer of a foundation warranty. And those seem to be the ones that sort of lurk in the weeds and nobody's quite sure how to get it done and get it over timely, but it needs to be on the seller to get that warranty transferred, though the contract doesn't say that there's a timing mechanism on that relative to closing. So anyway, so I think it's important also, and I'm just going to keep going here, Christina, until you cut me off. Uh, if you could pull up the first page of the contract, the and we're mainly focused on the 1 to 4, family resident. There it is. So it's important note at the top right corner that you're using the 11/7/2022 version of this. So this is the one that's on Trek right now, and so if you're accessing purely from Trek, you should be fine. But if you're accessing from another source or internally or whatever, make sure you get the current form, which is this is it. If you can see, it's dated 11/7/2022 at the top, and if you scroll down, Christina, at the bottom, it gives you the contract number. It's Trek number 2017. So I guess one of the most important things to do going forward on these contract changes is use the right form. And then if you go to paragraph 11, which is special provisions. I'm going to camp on there for a moment. Um, so they changed. I'm not. It seems like they were splitting hairs on these changes on what they're doing here, and and again, shouting out a warning to you about not practicing law and not providing legal advice and telling you what information can be put in special provisions, but something they left out and something to be thinking about. If Christine, if you could flip to that rule that we have, 537.11d, this kind of plays in conjunction. So look at this. This is 537.11d rule that is applies to use of track contract forms, And it's clear there it's not the practice of law for a license holder to fill in the blanks in a contract form authorized for use by this section. A license holder, here's the key part of this rule. A license holder shall only add factual statements and business details or shall strike text as directed in writing by the principals, meaning by your client. So, in that special provisions, paragraph 11, it doesn't mention that. And so I think overall, uh, you need to be aware of this rule, and probably most of you were, but just a simple reminder that, informational changes to the contract or insertions other than filling in the blank to the contract, you want to be sure you have authority, you have something in writing from your client. And this is a good rule just as a matter of practice, that on anything you do that's material or that you're passing on information, or in this case filling in special provisions, if that
Mm-hmm.
information is coming from the client and you're putting it in the contract, you want to have that authority. Or if that information's coming from the client and you're providing it to the other side, either to the seller side or to the buyer side, you want to have authority in writing from your client. That would be like an email or something
Mm-hmm.
confirming, or having evidence is the key here, having evidence that you were instructed to do this.
Okay. Very good. So have it in writing from the client. Very good. Well, thank you for going through that with us, Grant. It doesn't sound like very big changes this time around. I know we've had other times where there's many different contracts that get updated, but it sounds like this time it was minimal but very important to know about.
Yeah, I mean there was you got to be sure that if you're using cash, it really is cash sitting there in the sales price that you're submitting, that it's not something that you still have to borrow to get the
Mm-hmm.
cash or liquidate something. I mean, that's pretty basic. There was one, I think, notices provision on paragraph 21. Be sure that when you notice the buyer or seller with something, that you copy the agent involved. So that's something that they added, that the agents need to be copied on anything that's noticed to the buyer or the seller. And then I think it's 6E11, other notices, and these are notices related to MUDs and PIDs and those types of notices. You don't need to worry about adding seller disclosure notice of that part of the contract. That's already covered in paragraph 7. So that's a separate notice provision that they're talking about there. So anyway, I think these are pretty straightforward, but
Mm-hmm.
just a little bit of thinking to do on them.
Okay, very good. We had just a little thank you that came in for you from Delora Wilkinson. She said, "Thank you for attending the Trek meeting last week and all you do to keep our members informed." So we definitely appreciate
Laura's
that.
great, and she's been on commission now almost 6 years. It's
Hmm.
amazing. She's done an amazing job, and I can't believe that her term is almost up. And so, anyway, thank you, Laura.
Absolutely. Yes, thank you, Delora. Okay, so let's talk a little bit about the NAR lawsuits. You've come on our program many times to kind of give us status updates. There's a big status update, so why don't you go ahead and tell us about that?
Yeah, just for those just tuning in, there are lawsuits out there that could affect the industry,
Hmm.
and the main lawsuits are suggesting or challenging the MLS rule that requires the listing agent to provide some sort of compensation to the buyer's agent or buyer's broker
Hmm.
on a transaction. So you have this offer compensation rule that's imposed on the listing broker to offer some sort of compensation to the buyer's broker in any transaction. Doesn't tell you how much, but just the fact that it needs to be done. And
Hmm.
so the class action lawsuits have been filed saying this rule sort of imposes an unnecessary burden on the selling side of the transaction, increases the cost of selling a piece of property, and doesn't really give the seller a say so in negotiating that issue.
Hmm.
So there's multiple class actions. There's one in Missouri that covers in Missouri homes that have sold in the last 5 years, and there's a nationwide class action pending in Chicago. The one in Missouri is set for trial in October, and that's kind of the canary in the mine shaft, if you will, on what may happen. The one in Chicago is still pending as far as class action certification. It hasn't been certified as a class, which is a key component for the case to continue.
Hmm.
So waiting on that case, which is the bigger case, it's nationwide case, and the damage model on both these cases are just tremendous. It's unthinkable.
Hmm.
But the other kind of more current news is that NAR had reached a settlement on some related DOJ investigations of NAR practices and industry practices dating back to the Trump administration. And then when the new administration came in, they threw that settlement agreement in the trash can and said it doesn't apply to us. And NAR sued the Department of Justice, and just recently, last month, in mid-January 25 or 26, I believe, a federal judge ruled that the settlement agreement was enforceable.
Mhm.
And so it remains to be seen whether the DOJ is going to appeal that settlement or not, or that ruling that the settlement agreement is in place. I have to be honest, Christine. At the end of the day, I think it's a nothing burger as far as the effect on these other issues that
Mhm.
are staring the industry in the face, and other issues, meaning these other class action lawsuits, not just
Mhm.
on the broker commission issue, but also on the cooperation policy pending on in out in California, whether a listing has to go on the MLS when it starts to be marketed, or whether it can stay on a
Mhm.
private market, if you will. So that issue still listed,
So
still
what is,
exists too.
okay, so what is a potential impact here locally?
Well, the impact is if that case in Chicago, which is the nationwide class action possible class action case, here in Texas and across the country, if that gets class action certification, then you'll probably start seeing ads or getting mailers or, lawyers seeking to sign up clients that may have been affected
Mm.
by selling a property in the last 5 years under through an MLS, which includes ours. And
Okay.
so, that's kind of the actuality or the reality of what could happen. The overall, if worst case scenario, the NAR and the top brokers that are defendants in those lawsuits lose, I mean, it's a it's a big deal
Mhm.
financially, and nobody can really explain what may happen at that point.
Okay. So, what can buyers agents do now to protect themselves and maybe prepare for changes that might be coming down the pipeline?
I think it's the thing about litigation, which this is litigation. It's always uncertain. You can it's the constant in litigation is that it's always uncertain, and so it's the crystal ball is not real clear on what can be done. I think
Mm-hmm.
as far as preparing, I mean, there's no bullet point prepare. It's not like a hurricane's come in and go get water and flashlights and
Mm-hmm.
it's just not that simple. And so, but I think um, something to think about, because under attack here is part of the even within the DOJ or these class action lawsuits, the buyer's agent is under attack,
Mm-hmm.
and because the concept or the trend or the thinking in outside the industry is that no, with the internet and with websites like HR.com, the buyer doesn't need an agent. I mean, if
Mm-hmm.
they can find the property and case is over. I mean, big deal, move on, which is totally inaccurate.
Mm-hmm.
And I have something. Uh, Maybe it's yeah. Pull that up. There you go. Thank you. And so, as I said here, and I spoke about this back at Engage. I'm sure that your viewers saw it then, maybe. But I spoke about this at Engage, and it's this trend that there's no need for a buyer's agent. And the truth is, there is a need for a buyer's agent. So I just kind of came up with 8, topics that are critical for a client to have a buyer's agent, and why. And so I laid out some subjects here and some, and they kind of are self-explanatory as I lay them out there. But here's the key, that from a buyer's agent standpoint, is that you are important to the transaction. You're critical to the transaction, and you need to make that clear to the potential client or the new client. You got them. I mean, you got them signed up, or you're representing them. I mean, presumably through a buyer's rep agreement, but if not, uh, in theory. But I mean, one, if you don't have that client, as your client, you need to explain to them the importance of having a buyer's agent.
Mm-hmm.
Two, if you do have that client already and you're representing them, you need to come up with but much better list than I have here as to what all you're going to do. You know, as far as the process, it's not so much what all you're going to do for them. That can be part of it. Just what the process is. Okay, you found the property. Now here's the timeline, or here's the road we travel from A to Z for the next month, 30 days, 60 days, 2 weeks, whatever it is. That's called being a buyer's agent. That's called helping your client. That's called, fulfilling your fiduciary duty. And it's critical to this industry. And it's wrong to be under attack like it is right now.
So, does this make the buyer's rep agreement even more important?
It does. You can, from a legal standpoint, you can still be a buyer's agent based on the facts and how you're handling the transaction. But from a legal risk standpoint, and to protect yourself and to protect the buyer as well, the consumer, it's best to have a buyer's rep agreement.
Okay, very good. Now, like you said, there's a lot of changes, a lot of things could happen between now and I think you said October was when one of them's going to trial. A lot of
Yep.
things could happen. So, how can people stay up to date with what's going on with these lawsuits or any new policies that might go into effect?
Well, we're fortunate being HAR members or people who follow HAR to have Bob Hale. So Bob is talented, as we know, in so many areas, but a true talent, I mean, a really gifted talent he has is staying up and staying in contact with other people in the industry, and also staying in contact and reading, news daily, hourly, by the minute. I mean, he has owned the news information that is hitting this industry. And you know what he does with that? He takes all that background of experience, information, current events, Wall Street Journal articles, whatever it may be that he's reading every day on a daily basis, and he packages it into an insights email that goes out on Fridays to members. And so if you're not getting it, you should get it. But it's a wonderful capsule of information cutting to the important issues facing this industry and facing the members and facing the consumer for that matter. And so it's an easy read. You can pick and choose what you want to read. And to me, that insights from Bob sort of captures that information that's being put out in the industry, whether it be from Inman, the Wall Street Journal, whatever news source that exists out there, either in print or on the internet or both. He's on top of it. So it's a wonderful benefit to have and use and take advantage of.
Very good. And yes, usually around 10 a.m. Most Fridays, maybe not every Fridays during the holiday season and things like that, but check your inbox. You should be getting that from him on Fridays, typically around 10 a.m. And also, I just wanted to mention, because you said Inman News, all HER members have access to an Inman Select subscription, so we can drop that link in the chat as well. But if you're wanting to stay even more up to date, get those daily updates from Inman News, you can definitely subscribe there as well. So very good. Thank you for that, Grant. Thank you for that update. I think it's really important for us to just have an idea of what's going on. We those headlines, we may not see that they're impacting our day-to-day business at the moment, but they could down the road. So I think it's important for you to keep us up to date with that stuff for us so that we're ready.
Yeah. And NAR makes an attempt, and a good attempt, to keep members up to date on what's going on in litigation. You can always go to the NAR website and find information about the status of the lawsuits and so forth.
Okay, very good. So let's talk a little bit about social media. As you know, as HR's director of social media, I see a lot of what realtors are putting online. What are you seeing from realtors on social media that could potentially get them into trouble?
Well, yeah, that's it used to be a lot. It seems, I don't know, maybe it kind of runs in, peaks and
Phases,
valleys.
yeah.
Right. Sort of like my yoga workout. But um, it's just, well, first of all, being kind and not being hateful. I mean, these are ethical issues. Not saying things that are unkind or hateful on social media. I mean, there shouldn't have to be an ethic rule in that, but there is. But that's just business 101. Why would you act that way in a business where the consumer is your client?
Mm-hmm.
and all consumers, presumably, not just certain consumers. So that's always be put a filter on what you're thinking or saying as far as when it gets to the public airways, if you will. And if you're having those thoughts that are unkind or hateful, then deal with them in another manner, not through social media.
Mm-hmm.
And then another thing that is still can be a risk is how you advertise on
Mm-hmm.
social media, what you include or don't include as far as following Trek rules and having your sponsoring broker as part of the advertisement, and then also just saying things that are not true potentially about a piece of property or about an area or a neighborhood, which leads to another one. You can't target certain people within the consumer class and say, here's where I'm targeting this property to,
Mm-hmm.
and to the exclusion of other members, to other people in society, whether by race
Mm-hmm.
or religion or sex. You can't itemize, if you will, on who
Mm-hmm.
you're trying to sell the property to. That's fair housing violation, and that's actually not, and perhaps not being your best fiduciary to your seller by limiting who it's being sold to. And I guess the other one I see is copyright. Still, is certain agents will still just grab a photo or grab something that is intellectual property based product or item, trademark, trade name, most often a photo that doesn't belong to them or they don't have a right to, and they post it or make it a part of what they're doing on social media. And of course, you can get into a lot of trouble in the sense of getting a lawsuit or getting assessed a penalty under the Copyright Act for using somebody else's intellectual property without their permission, not commission, permission. So
Okay.
that's what
Yeah.
I'm saying, or those are typically the areas that are a concern.
Very good. Well, as we know, April is Fair Housing Month, but obviously something we need to be thinking about year round. And also, you mentioned the advertising rules. I know I personally get a lot of questions about truck advertising rules. I think they maybe went into effect in 2018. I think that might have been one of our first member focus Mondays, you coming on to tell us about truck advertising rules. But they have that very clearly stated on their website. If you just Google truck advertising rules, you can find them for social media. You can find them there.
Right.
So,
It should be. I mean, there's been enough, as you point out, kind of back and forth, and what does this mean, and da 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 da
mm-hmm,
da. And so it should not be a gray issue. Should be pretty clear.
very good. So, I often hear you say to members, and you actually said it a little bit earlier in this interview, don't get caught practicing law. What do you mean by that when you say that to our members?
Well, I mean, look, I understand that members wanting to help their client. I mean, they are no duty to help their client. I mean, that's part of the business. But you have to rein yourself in sometimes in order to not damage your client by trying to help your client.
Mm,
And what I mean by that is giving legal advice on something that you're probably better off by letting somebody else, like a lawyer, discuss. And so, where I see it come up is trying to explain deed restrictions to
mm,
a client and not really having a real good handle on that. And so sometimes if it's a real critical issue or just the language of the deed restriction or how one might interpret what it's saying, you need to get a lawyer. And so
mm-hmm,
same thing on a title commitment policy. When you get the title commitment, just be careful about, it's okay to go over it or discuss it, but be careful about interpreting it. If there's something there that doesn't make sense or you're not sure of and you get a question about it,
mm,
that needs to be handled by a lawyer. And so, and then sometimes you get an amendment to the contract that's proposed by one side, and maybe it's a little bit wordier than typical simple amendments. And, there you know, again, be careful about trying to do it all. And
mm-hmm.
maybe that amendment needs to be reviewed by a lawyer to be sure that it is saying what y'all wanted to say coming from the other side.
Okay, yeah, that makes sense. I still have a few questions for Grant, but if you have questions for Grant, type those into the comments and we will get to as many of those as we can. So far, just a lot of comments coming in. They love Bob Hill's Insights newsletters, which we all do. And of course, as always, they're saying Grant is so informative. So they're really appreciating what you're sharing today. About 2 years ago, Grant, you came on our program. with noted antitrust attorney Alan Van Fleet to discuss antitrust issues within our industry. Are you still seeing that as a big issue for realtors?
Yeah, it will always be an issue in the sense of not so much. I think a member intentionally saying, "I'm going to wake up and go violate the Sherman Antitrust Act today." That's my goal. So, I mean, well, yeah, I hope it's not that
Right.
and had that kind of intent. But anyway, yes, it still exists, and I think it dovetails or it kind of fits together with being a fiduciary. I mean, I think where it comes up is where a agent decides it's not going to show a property because of who is selling it or who is listing it, or it's not an MLS, or maybe it's a FISBO, or maybe it's a builder who has a different way of doing things,
Mm-hmm.
and so you sort of in your own mind sort of boycott or not or decide not to show that property for certain reasons, and so I
Mm-hmm.
think that's where I say it's almost like there may be an antitrust issue, but there's for sure a fiduciary duty. They kind of go together. I mean, if you're hurting your consumer from a competitive standpoint, then you're hurting your consumer client as a fiduciary.
Mm-hmm.
And so anything that puts your interest ahead of your client's interest is a violation of your fiduciary duty, and could also, depending on the scenario, the type of the money involved, commission involved, those sort of money issues could be an antitrust issue. And so, bottom line is to avoid antitrust or fiduciary, always put your client ahead of your own interest.
Okay.
Hey, one other thing I forgot,
Mm-hmm.
Christina, before we leave this, on the social media policy, there's a good
Mm-hmm.
link on NAR's website about for brokers to develop a social media policy if they don't
Mm.
have it, and we can share that with them if needed.
Great, excellent. We can definitely share that in the chat so people can review that. And, uh, I know we have brokers tuned in this morning. Might be something that they decide to implement as well. So thank you for that, Grant. Um, with a massive increase in members over the last 3 years or so, does that pose a risk for brokers? And what do you suggest maybe brokers do to ensure these agents are properly trained? And also, maybe you're a realtor and you're working the other side of a deal with a new agent. What are some things that we can be doing to make sure these newer agents that have entered the industry are prepared?
Well, yes, there is a risk because you have a whole influx of thousands of new agents, not just in the state, but in Greater Houston. Think
Mm-hmm.
about that. So, I mean, any industry would have that issue. I mean, whether it be the airlines, the trucking, whatever, if you had an influx of new people into your industry, there's going to be a heightened alert to risk. And I think the most, I mean, we can say training, and yeah, you need to train them and
Mm-hmm.
mentor them, and we know that. And sometimes I know that's hard to do, but I think the key is that you need to instill in that licensee's mind that you're here for them. And if that
Mm-hmm.
issue comes up that they're unsure of, or they don't know, or they can't get an answer to, they need to come to you as the broker or the manager or the supervisor, whoever that person is. That they need to have in their mind as a new agent that when issues come up that are maybe outside their control, that to not ignore them, to not deny them, but
Mm-hmm.
to bring them to you, the manager, broker, or supervisor, or whatever, and share that issue with them. And on the other side, on the management side, you need to be responsive. So I
Mm-hmm.
think I think the key is this interplay between new licensee and management, that we're here to help, but you need to let us know when you need help, and then we're going to respond timely and with material information that helps you. So I think that's
Mm-hmm.
uh, the key part of that.
Okay, that makes perfect sense. We had a question come in from Cindy Heyman. She asked, "What do you think will happen with home buyers who bought in the 2021 frenzy? Do you see potential lawsuits since prices have dropped and no appraisal and inspections took place?"
Well, that was, lawsuits would always increase when, buyers would get upside down on a transaction. They overpaid for it,
Mm-hmm.
and then something goes wrong, and then the whole bottom falls out. And so I'm not seeing that yet, Cindy. So that's good news. I mean, I think even though the prices may not be escalating or maybe not at list price selling or things that are more normal in our normal sense of practice of real estate, I haven't seen it yet get to an extreme where the bottom is falling out of prices, and so people are going upside down on a particular property,
Mm-hmm.
and then other issues popping up, and so they're turning for somebody to blame on the financial situation they're in that's maybe compounded by a leaky roof or whatever the issue may be. So I believe me, I lived through those days when everything just came thundering down and lawsuits were flying all over the place. I haven't seen that yet, and I don't anticipate that happening just yet. I mean,
Mm-hmm.
I think there would have to be another disruptor to the industry for that to occur.
Mm-hmm.
And I think Christina, you had mentioned earlier, what about a new licensee and a transaction? What do you do? I think that probably typically shows up on the list side, meaning that the listing agent may be the veteran and the buyer's agent may be somebody new.
Mm-hmm.
So, but whatever the scenario, maybe it's buy side, maybe it's the list side. You, the experienced one, dealing with an inexperienced one, need to make sure that you are not only protecting your interest of your client, but also watching what that other agent's doing, and maybe you know filling in and doing things that you might not normally do in order to make sure that your client is properly represented in the
Mm-hmm.
transaction. So don't just ignore it and say, well, whatever happens, happens, because I promise you, whatever may happen may come back on you, even though you did nothing wrong. So be conscious of that new person or that unexperienced person in your transaction, and prepare and plan around it and as part of it.
Okay. One thing that we don't talk about often, but could be a potential source of risk, especially for brokers, is when it comes to protecting client information. What can realtors and brokers do to ensure they aren't liable if there's a security breach, for example?
Well, I think just a reminder, and maybe hearing it for the first time, I don't know, but you
Mm-hmm.
know, email is not the way to transmit or send or provide private information, whether it be
Mm-hmm.
cell phone information, whether it be driver's license, whether it be social security number, whether it be um, wiring instructions. A base email without any sort of password protection it should be history. That's the old way of doing things, and to some degree that applies to text also. Text can also be vulnerable to hacking or somebody getting inside with spyware and knowing what you're doing.
Mm-hmm.
So those sort of basic ways of communication are sort of from the past, and you have to be more password sensitive, or through your own an association network or your broker's network that is password protected, provide that information. And so that's sort of just fundamental general rule number one.
Mm-hmm.
And just in general, I mean, whether going back to social media or other ways of communicating information about your client, you got to be sensitive about what you're saying about the property, about the client, and some of those things are sensitive to a client. And so be sure you know your client, or be sure you have your client's permission when you might be releasing some sensitive information or private information about the property or about the client.
Mm-hmm.
It may be important, it may be necessary to further the transaction that's pending, but be sure you have your client's permission to do that.
So, I mean, obviously, this is something every agent should be taking into account. But as far as from a broker standpoint, I mean, can a broker be liable if this information were to be leaked or something?
Or anything a licensee does in the furtherance of broker services, which, information or anything related to a transaction, yes, the broker is responsible for.
Mm-hmm.
So, it's a pretty wide net as far as broker responsibility, but if whatever the licensee or the agent's doing on behalf of the client or the transaction or something related to either one of those two, then yes, it's going to fall on the brokers as being responsible for that conduct or that lack of conduct. by the licensee.
Okay, so definitely maybe an area where a broker might want to have another policy similar to the social media one you mentioned earlier.
For sure.
Okay, well, very good, Grant. We've gotten a lot of thank yous. People are really appreciative of the information you shared today. Is there anything else that you want to share today? Anything else that you think our members need to know?
Well, I think it's sort of back to what you said earlier is sort of the crystal ball. What do we do? There's a lot of disruptive forces out there that we don't have any control over, and I
Mm-hmm.
guess I would say that's kind of your response. I don't have any control over the lawsuit pending in Missouri, or the one in Chicago, or the one in California, or the one still to come, or what the DOJ may do. I think as the market sort of shrinks, if you will. I mean, it's not as wide open as it was. It's becoming
Mm-hmm.
more competitive. So what does that mean? That means you need to be more competitive. And going back to what I explained about a buyer's agent, you need to showcase what you can do in a transaction, and not just showcase it, do it.
Mm-hmm.
And so I think it's a competitive market. So be more competitive. Keep doing what you do best. Stay aware of what's going on by reading insights from Bob Hale each week, and just be informed, be educated, be polished, be competitive, and be calm. Everything will be okay.
Well, excellent. Thank you, Grant, again for your time this morning. We always appreciate when you take some time to join us and give us some updates.
You're the best, Christina. Thank you.
Thank you. Next Monday, we will be back with Felicia Guidry. She is chair of the Houston Black Real Estate Association. She's going to fill us in on all of the great work they do and some different educational opportunities they have available. So we will see you all next Monday at 9 a.m. Have a great week, everyone. Bye bye.